Any mention for unlisted matter? Any mention for unlisted matter? From the main list, item number 1.
May it please your Lordship.
Yes.
My Lord, this is a case, my Lord, this income tax appeals. While hearing the appeal, my Lord, Lordship looked into two substantial question law I have formulated. Number 1, my Lord, that tribals doing business in the scheduled area, my Lord, and if they form a farm, my Lord, both the partners are tribals, will they still be entitled for exemption? And number 2, my Lord, was very crucial, that this issue was decided in an earlier case, Mahari and Sons, which say, my Lord, even the group of tribals, so long they are earning their income from scheduled area, they are still entitled. So my Lord doubted that ratio laid down in Mahari and Sons. And on the ground that, your Lordship, the cardinal principle of taxation law is this, that, my Lord, in case of exemption, it requires a strict construction, and any ambiguity, your Lordships, that should go in favor of the revenue, not the SSC. And that's how it was referred to a larger bench. But ultimately, my Lord, Honorable Justice,
Yes.
thank you, my Lord.
You're ready?
Lordship, we file our affidavit, Lordship.
Yes. You're ready to proceed?
Lordship.
Very good. Yes.
My Lord. So that's how, your Lordships,
Yes.
could not take up, then matter has come back before the division bench. Now, my Lord, before I get into, my Lord, into this aspect, your Lord, Mahari and Sons, my Lord, there are certain other technical aspects I need to point out to your Lordships, pertaining to, my Lord, Northeastern Area Reorganization Act. Now, my Lord, this is an act, Northeastern Reorganization Act, my Lord, is an act by which, my Lord, 3 states were, or in 71, my Lord, 3 states were created. State of Meghalaya became a full-fledged state. Tripura and Manipur, my Lord, which were so long, my Lord, union territory, they were upgraded into, my Lord, full-fledged states. And, my Lord, then there were a requirement for providing a, my Lord, common high courts. And then, my Lord, Meghalaya was under the common high courts. Then ultimately, my Lord, the separate high court was set up, Lordship, for the state of Meghalaya. The appointed date was, my Lord, 23rd March 2013. Now, my Lord, certain arrangements, my Lord, with regard to the power of the common high court, pertaining to the decision, my Lord, passed prior to the appointed day, has been envisaged, my Lord. I'll just point out those. This body, GLR. This Lordship. Yeah. If your Lordship can take to the, my Lord, amended provisions. (28I). (28I), my Lord. Shall I read it?
Just a second. What is this statute?
This statute is called, my Lord, Northeastern Areas Reorganization and Other Related Laws Amendment Act 2012. Section, my Lord, 28I.
That's section 20. That's section 4 actually.
28I.
That's section 4.
Lordship. Not subsection 4. Before also, my Lord, there is a provision, if I can read. There is 3, my Lord. Subsection 3. May I read it, my Lord?
Three is all right. Section 4 is
Section 4, yes. Any order made by the Common High Court before the commencement of Northeastern Areas.
Just a second. Where are you reading?
My Lord, 28I, subsection 4. Any order made by the Common High Court.
I.
Lordship.
Insertions, then section 20, no, 28 I-4.
Lordship.
Yes.
Any order made by Common High Court before the commencement of Northeastern Areas Reorganization and Other Related Laws Amendment Act 2012 in any proceeding transferred to the High Court of Meghalaya or the High Court of Manipur or the High Court of
We've
Kewar.
seen that. We've seen that.
My Lord, what I am stressing, Your Lordship, subsection 2. My Lord, subsection 3, my Lord, I'm sorry, subsection 3.
Yes.
Notwithstanding anything contained in subsection 1 and 2 or in section 28A, but save herein
Subsection
under...
3 is of no importance to you.
My Lord, if I-
What is of importance to you is subsection 4.
My Lord, subsection 4, my Lord, is saying, my Lord, any order passed by the county
Yes,
we have order by.
will be followed as if it was made by this High Court. So therefore, as if it was made by division bench of this court. Yes, very good.
This is one point which I have made already. Other point, my Lord, why I am trying to, my Lord, emphasize. 3 say, my Lord, that any application for review or other proceedings pertaining to, my Lord, an order passed before the appointed day by the Common High Court, my Lord.
Let us see.
Lordship.
Applications for review or other procedures such procedures review. There is no application for review.
My Lord, my humble submission, my Lord, if I can add other proceedings. My Lord, when if you,
No.
if your
No,
Lordship
that's right.
seeks to, my Lord,
Review, etc.
my Lord, if the court of its own motion, my Lord, any earlier decision is sought to be reviewed, my Lord, this also will be a proceeding.
28 I-4 applies, but 3 does not apply.
Lordship.
Yes. Now let's get into the place the order of the tribunal. What is the date of the interim order, Mr. Sen?
Lordship. That is order dated, my Lord, 13/9/2019. That is, my Lord, I have 13/9/2009.
2019.
My Lord, I have submitted 2 compilations, my Lord. It is in one of the compilations, my Lord, which is under the heading, my Lord, index and list of dates.
You don't appear to have it.
Which is it? 72.
That's the paperwork.
Paperbook and annexes.
Paper book and annexes, Your Lordship.
It's the paperwork itself, yes.
Page.
Page 72, man.
'72.
Lordship.
This. It's called paper book of annexures, yes. Yes.
My lord, findings are at page 97, your lordships. Paragraph 21 onwards. My lord.
No, it's long before that. It's long before that. It's from 94.
17.
94, paragraph 17.
Yes, 17.
Yes, please place it.
Yes, ma'am. We have given our thoughtful consideration to the foregoing rival contentions. Relevant case records as well as various judicial precedents quoted during the course of hearing stand perused. We wish to make clear, first of all, that there is no dispute between the parties about the basic relevant facts. The SSE is a partnership firm consisting of two partners having equal share. The members of Khasi tribe entitled for 1026 exemption in their individual capacity since covered under Article 366 of the Constitution of India. The question that requires our apt adjudication herein as to whether the SSE partnership firm itself can also be held to be entitled for the impugned section 1026 exemption, since its two partners are already eligible for the very relief. 18. Article 265 of the Constitution of India stipulates that taxes are not to be imposed qua by the authority of law. No tax shall be levied or collected except by the authority of law. The legislative enacted the Income Tax Act 1961, therefore, to provide for levy and collection of tax on income earned by a person comprising of 1 to 7 categorized in often categories of an individual, HUF, company, a firm, an association of persons, or body of individuals, whether incorporated or not, a legal authority, and every judicial person not falling within any of the above specified classes under Section 231 of the Act. It's further inserted in Chapter 3 in the Act comprising of Section 10 to 13b, specifying the income which do not form part of total income for the purpose of assessment and levy of tax. Since the instant lease raises the issue of ambit and scope of Section 1026 thereof, we deemed incorporate to reproduce the same as hereunder. 1026, income not included in the total income. In computing the total income of a previous year of any person, any income falling within any of the following clauses shall not be included. 26. In the case of member of scheduled tribe, as defined in clause 25 of Article 366 of the Constitution, residing in areas specified in Part 1 or Part 2 of the table appended to paragraph 20 of the 6th schedule to the Constitution of the state of Arunachal Pradesh, Manipur, Mizoram, Nagaland, and Tripura, or in areas covered by notification number such and such, dated 23rd February 1951, issued by the Governor of Assam under the proviso to subparagraph 3 of the said paragraph 20, as it stood immediately before the commencement of the Northeastern Areas Reorganization Act 1971, or in Ladakh region of the state of Jammu and Kashmir.
So, over here we find Meghalaya is not specifically indicated. Several states, Arunachal, Manipur, Mizoram, Nagaland, Tripura,
Lordship.
and Ladakh,
Lordship.
they are indicated by their state or by the region.
Lordship.
But Meghalaya is not indicated. Meghalaya will be only those areas which are governed by the paragraph.
Paragraph 26 schedule. It is clear that The specified A-B member of the scheduled tribe only is covered under Article 366 of the Constitution of India, enjoys exemption of his income derived from any source in the area, and also income from the dividend and interest on securities. It transpires from the perusal of the above statutory provision that legislature has not only granted exemption income of any person only, but also it applies the impugned benefit in case of a member of scheduled tribe only. 19. Apex Court has also been settling the relevant principle of interpretation to be adopted in case of taxation law from time to time. Their Lordship's latest Constitution Bench decision in Messrs. Dilip Kumar and Company and others.
Where is, what is the reference of this?
Reference is, my lord, I have this decision. This is, I've given a list of books, my lord. This is Dilip Kumar.
Just give us the reference.
This is, my lord, 2018, 9 SSC, page 1.
Yes. Carry on.
Stage should be interpreted strictly. Further, in case of ambiguity in a charging provision, the benefit must go in favor of a subject, SSC, but the same is not true for any exemption notification wherein the benefit of ambiguity must be strictly interpreted in favor of the revenue state. Their Lordship, yet another decision in Rai versus Company, etc., holds that it is the cardinal rule of interpretation that a word used by the legislature are to be understood in their natural, ordinary, popular sense and constitute as per the grammatical meaning unless such a construction leads to some absurdity or there is something in the context or the subject of the statute to suggest to the contrary. Their Lordship also invoked the golden rule of interpretation that words of a statute must prima facie be given their ordinary meaning only. Honorable Apex Court, yet another landmark decision, Simati Tarulata, Shyam and others versus Commissioner of Income Tax also holds that there is no scope for intendment of tax law as follows. We have given anxious thought to the persuasive arguments which, if accepted, will certainly soften the rigor of the extremely drastic provision and bring it more in conformity with logic and equity. But the language of the section is clear and unambiguous, and there is no scope for importing into the statute the words which are not there. Such interpretation would be not to be construed, but to amend the statute. Even if there is a cause or makers, the defect can be modified only by legislative and not by judicial interpretation. Then 21. We proceeded to examine with the instant issue of SSC partnership forms entitlement for section 1026 exemption in the light of the above narrated facts and its settled principle of interpretation of tax statutes. It has placed a heavy reliance on Honorable Guwahati High Court's decision in Mahari and Sons, affirming the tribunal's order dated 1026 exemption does not apply only in the case of individual but to a Khasi family as well. Their Lordship have taken note of the beneficial nature of the provision to uphold the tribunal's order on such and such, that the legislature had deliberately not used the word individual in section 1026 but employed the expressions person, which is wide enough to include in its ambit unit as the Khasi family structure as under. Then, my lord, this 10A was the, my lord, part of the judgment rendered by the tribunal. This is not of the High Court. Shall I read it? 10A. On the second count, however, we are not inclined to accept the contention of the learned departmental representative. The ordinary state of Khasi society is that of jointness, wherein the individual is not the unit of society. The families constitute the clan, and the various clans constitute the society. The ancestral properties, as in the present case, are inherited and held not by an individual for her own exclusive use, but by a ka khaddu for the benefit of the entire family, which in the case of Khasis is before marriage, and if he dies before getting married, goes to his mother or kur. The earnings of the male are regarded as part of the family earnings and are placed by him at the disposal of the mother. Even if he keeps some income for himself, on his death, his mother or her nearest female court takes it. After marriage, the Khasi husband goes to live in the house of the mother of his wife or in the house of his wife. Before the wife has a child, the husband uses sufficient part of his own earnings for the maintenance of his wife. The surplus or portion of his surplus he may give to his spouse. After the birth of the child, the husband and the wife work and earn jointly for the child. The husband works with the wife on the land or engaged in the trade with the capital supplied by her. The earnings of the male in such a situation cannot be distinguished from those of his wife. The individual property is thus not the norm in the Khasi society. It is of course not to suggest that the Khasi male cannot have his own property earned by his own sweat. There are men of considerable property who will dispose of that property among their relatives as they deem fit. By pointing out the above peculiarities of the Khasi plan, the point that is sought to be emphasized is that amongst the Khasis, the individual is not the unit of the society. It is the family which is the unit, and if this plurality is kept in mind, it would be immediately obvious that the ancestral properties would always be held by Ika Khaddu of the family, and most of the self-equate properties also would become the properties of the family, either on the mother's side or of that consisting of wife and the children. The use of the word person in section 1026 in the context of the above peculiarities of the tribal law assumes importance. The legislature has deliberately not used the word individual in section 1026, as has instead used the words person, which is wide enough to include in its ambit a unit as that of Khasi family, as in the present case. It is difficult to believe that the Parliament intended to grant exemption only to Khasi individuals who own properties, though only marginally, and intended to leave out the bulk of the Khasi society wherein the properties and business are owned by the family units and in which the individual members do not have any determinate interest and, unlike Hindus, cannot even ask for division of the properties. If we interpret section 1026 as suggested by the revenue, we would be rendering the exemption illusory. Apart from it, it would not be accordance with the deliberate language used by the Parliament. We notice in this backdrop that since the sacred family fibre as per Khasi scheduled tribe remained intact as per the relevant convention for the entire family being assessed as a body individual under section 231 of the Act, the learned coordinate bench had not examined another clinching statutory expression in case of member scheduled tribe. It is in this backdrop of fact that we hold that the learned coordinate bench decision to be par incuriam and not binding precedent in view of the Commissioner of Income Tax versus BR Constructions. We also wish to make it clear that the beneficial interpretation taken recourse to in the above stated decision no more holds the field, going by the Honorable Apex Court's recent constitutional bench judgment. While observing so, we are very much conscious of the fact that the Honorable Guwahati High Court acted as the Honorable Jurisdictional High Court as well till March 2013, when the Honorable Meghalaya High Court at Shillong came to be established after suitable amendments of the Constitution of India and Northeastern Areas Reorganization Act 1970. Be that as it may, their lordships of the Honorable Apex Court have settled the law now that the benefit of doubt in relation to an exemption provision in a tax law goes in favor of the revenue state and not to be the taxpayer anymore. We allow the same to hold that the SSC's argument that partnership firm is a member of scheduled tribe is not liable to be accepted. We also make it clear that this is going by their lordships foregoing landmark decision. There is no course left for us to hold that there is any scope of intendment of the impugned statutory provision stretching the impugned exemption to a partnership firm as the member of scheduled tribe under Article 366 of the Constitutions. Well, this is basically the findings. Then 22, the SSC's argument that Section 13 of the General Clause Act 1897 treats masculine and singular expression in central regulation to be interchangeable famine, gender, plural expression also carries to the substance, since the legislation expression herein is very much clear that the impugned exemption benefit available to a member of scheduled tribe only takes to a partnership firm consisting of partners who are member of such scheduled tribe. We reiterate that the said provision General Clause Act itself contains a stipulation unless there is anything repugnant in the subject or context. We therefore decline to the SSC's instant argument as well. We make it clear that whilst holding the Income Tax Act is a complete code in itself, in the nature of specific law, which applies at the cost of the general laws, going by the legal maxim, general such and such manner, as per the Honorable Apex Court Union of India and another versus Indian Fisheries. We also wish to quote the Honorable Apex Court decision in Jalandhar Vegetables, holding that though the partnership firm is not a...
What is the reference of this, Jalandhar Vegetables?
Jalandhar Vegetables, isn't it? I have annex, no?
Yes, there.
You have annex? Jalandhar Vegetables. My lord, AR 1966.
Yes.
Page 1295.
1295.
Yes, my lord. AR 1966.
Right.
SC.
Thank you. Yes, continue. Please.
1295. It is there, my lord. I have annex page 86 to 90. No, sorry, my lord. I have not annex. I'm sorry. Then, my lord, 24, Learned Counsel has also referred to the various statutory provisions, there is section such and such, and the legislature has explicitly incorporated the statutory exemption individual as against person in section 1027, meaning thereby that it intends to provide the impugned exemption to all categories in section 231 of the Act. We see no merit in the instant plea as well. We notice that section 1026 come into play in case of a member of scheduled tribe notified in Article 366 of the Constitution of India. Similar exemption clauses, section 26A, is applicable to any income accruing or arising to any source in the district of Ladakh are admittedly applicable in case of individual. HUF Farms Association of Person and Company under section such and such deals with an individual only respectively. The necessary inference that flows from the comparative analysis of all these exemption provisions is that 1026 preposes any person who is also a member of the scheduled tribe as against 1026A and 1026AAA applicable in case of specified categories of person respectively. We also involve the doctrine of necessary implication in this backdrop, that what is implied in the statute is as much a part thereof as that what is expressed. We thus find no infirmity in CIT's lower appellate court orders upholding the assessing officer's action that the SSE is not entitled for exemption benefit under 1026 of the Act. Coming various judicial precedents quoted as the SSE's behest, we find that none of these deals with an instant of interpretation of an exemption provision of tax laws. Their lordship determine interplay between the partnership firm and its partners, compendious structures, former formations, and joint business carried out by the former's name, followed by distributing profit. There can be no dispute about the law settled therein. The same, however, does not apply the issue of section 1026 exemption before us. In view of our foregoing detailed discussion, we accordingly decline the case such and such. Some order to follow former SSC remaining. My lord, these are the operative parts.
Yes.
Yes, my lord. No, my lord, my past contention, your lordships, on the other day, your lordship, while lordship has referred this to the full bench. So my lord's prima facie, my lord, impression is this, and which has been reflected in the tribunal judgment is also, that the cardinal principle of law is this: in the matter of exemption, my lord, is to be construed very strictly. In case of any ambiguity, my lord, that should go in favor of the revenue, not SSC. No, but that has been came to be, because there are two kind of exemptions. One is general exemptions, my lord, and other is, my lord, beneficial exemptions. That came to be distinguished in a subsequent decision in 2021. And that Dilip Kumar Chaudhary was referred to. There the Honorable Court held, my lord, that the traditional views of our, my lord, the beneficial exemptions are concerned. Still a liberal approach, I mean, liberal interpretation is required to be given. What has been discussed in Dilip Kumar Chaudhary, that is pertaining to, my lord, general exemptions. So that traditional view pertaining to, my lord, beneficial exemption, my lord, still hold the field. My lord, that judgment, your lordships, that judgment 20, my lord, 21, 5 SSC, page 602, your lordship. Government of Kerala and others by the Mother Superior.
What's this?
That is, my lord, Government of Kerala and another versus Mother Superior Adoration Convent.
Very good. Mother Superior.
Well, there. Because there, my lord, exemption
Have
was
you given us any compilation? No.
this. I have given a list of books, my lord. There, this one I have given compilations. Relevant, my lords. 23, my lord, paragraph 23.
No.
So, lordship. Issuing of notice after the dissolution.
Yes.
So, my lord, what I submit, my lord, so far, my lord, this exemption to the tribals in the schedule area, and my lord will appreciate the fact, so far 6th schedule is concerned, my lord, this is the creation of the Constitution of India, taking into consideration, my lord, the socio-economic condition and the unique culture. They are really trailing, my lord, we're way behind to catch up with the mainstream country. Now, my lord, by the language of the Income Tax Act, my lord, if an exemption otherwise, my lord, indicated, your lordships.
You see the ratio in this last judgment, Mother Superior, relying on several of the other judgments, including primarily on the Vadilal judgment,
Lordship.
is the purpose. The purpose of the exemption.
Lordship.
The purpose of the exemption is quite different from the person who is granted the exemption.
Lordship.
Over here, we are on the person who is granted the exemption. The person who is granted the exemption is expressly said to be a member of a scheduled tribe. When it is a member, these are on the purpose of the notification.
Lordship.
The purpose of the notification in the Mother Superior case, the exact case is whether a building which was used as residence for nuns could be regarded as a building principally used for the purpose of education for it to attract the exemption. There is no dispute that the building was used as a residential building. So when the SSC applied to the state government said that there may be 4 buildings. Out of the 4 buildings, in 3 buildings, educational purpose, education is being imparted. We treat them as exempted. But this is used only for residential purpose and this cannot be granted that exemption. The logic against it which is used by the Kerala High Court is that, and in the full bench judgment, is that when educational institutions provide hostel, that is in furtherance of the education. And when educational institutions provide place for staff to stay, that is in furtherance of the education purpose. And if you notice, Justice Nariman went on the word principally and interpreted that if principally that is used for the, not exclusively, if principally it is used for the purpose of education, now you have 4 buildings in any premise. 3 buildings are classrooms, 1 building is residential, 1 building is for faculty, 1 building is cafeteria. All of them have to be taken to be principally for the purpose of education. And you cannot pick out 1 building and say, since that is being used as cafeteria and commercial activity, that is not exempt, that is used as residence, that is not exempt, that is as hostel, that is not exempt. You got to look at the totality with the object in mind. Similarly, the case that it relied on are all Andhra Pradesh cases where to promote industry, you gave an exemption. The principal case that is relied on was covered by 1993 notification which granted exemption to that industry. What was the industry? The industry was buying bulk of a material, of some material and bottling it to sell it in the retail market. Now, according to the excise rules, that does not involve a process of manufacture, because a process of manufacture is conversion of some material into another material. Bottling, by getting huge quantity and supplying them in small quantity, would not amount to manufacture within excise laws. But the court said no. The original notification which granted them exemption Where manufacture was used in a larger sense was for the promotion of industry. And therefore the word manufacture used in excise laws cannot be confused with how manufacture was used in the exemption notification. Those are purposes. Over here we are not on purpose. We are on the person who's granted the exemption. The person who's granted the exemption is very clear. A member of a scheduled tribe is a partnership firm, a member of a scheduled tribe within the meaning of 366.
If I can just point out one thing. My humble submission, my Lord, 1026 has a twin purpose. One, encourage the tribal entrepreneur. Not
No. Don't read into it.
No, my Lord.
1026 clearly gives,
Token Singh Rimbai.
subject to two conditions being fulfilled,
Lordship.
it exempts tax being paid by members of a scheduled tribe. What two conditions? That he has to be a member of a scheduled tribe and he has to be in the specified area. Now there is no dispute that if this entity can be regarded as a member of a scheduled tribe, the second condition is fulfilled. There is no dispute. But can this entity be regarded as a member of a scheduled tribe?
Token Singh Rimbai. Token Singh Rimbai, where is that? Token Singh Rimbai. Token Singh Rimbai. My Lord, in fact,
And that is where the Dilip Chandra case comes in.
Lordship. No, my Lord,
Because this is general exemption.
Lordship.
This general exemption. This is not only to Khasi tribe in Meghalaya. This is general all over the country. This is not confined to 6th schedule.
No, my Lord, so far 6 scheduled areas are concerned, my Lord, in Token Singh Rimbai. Token Singh Rimbai, my Lord, the Apex Court has held, it has a twin purpose. One, encourage the tribal entrepreneurs, and secondly, they say within the scheduled areas, to bring about the economic activities within that area.
Very good. The individual will be exempt.
My Lord.
And that is the exemption which is granted.
And my Lord, to bring about the development in the tribal areas.
We are all in agreement with that. No one is taking that away
Lordship.
from the person who has been granted that exemption.
Lordship.
When you talk of purposes, person is identified. Purpose, liberal construction. But what you are trying to do is you are expanding the scope of person. If the word used is Indian, you can't enlarge it to Asians. The person indicated is a member of a scheduled tribe. Partnership firm is not a member of a scheduled tribe.
But then your Lordship will look into that language. I think I have pointed out, my Lord. The opening paragraph is the following persons.
Sorry?
Following persons. The opening paragraph, exemption, my Lord, 10, starts with the income of the following persons.
Yes.
Then there are other provisions, my Lord, when that the exemption has been extended in individual capacity. They have categorically mentioned
Maybe
individual
person, but
income
the
of
person is clearly defined over here.
Lordship.
Person is clearly defined over here. Plus the other logic which is used by the tribunal in Mahari is equally fallacious because it refers to the Khasi family. If the exemption were to be granted to the Khasi family on the basis of the family structure, then like HUF they would have also provided for Khasi family. But the law has not provided for that. Law has not provided for a Muslim undivided family. It has provided for an HUF. You may say that the law is arbitrary. But that is the law. And HUF is regarded as different. There is no similar provision for a MUF or a CUF or any other tribal united family. We are not on the purpose. Purpose is, we can't question it. It's for the benefit of these people where there was very little income, where there was very little backwardness.
Lordship.
Today we also have to take judicial notice that Shillong is not backward, nor is anywhere else in, look at the mobile network penetration.
The rural areas are still.
Have you been to the rural areas? Every child and his friend has a mobile phone.
Yes. No.
The situation is not that good, my lord, in the outskirts.
You don't know as much as I know, sir. I've traveled the last mile. Even in places which have very little facilities, the southwest Garo and the south Garo, where there is no high transmission electricity line, even there is full penetration of FMCG. And mobile phones. Anyway, we need not go into that. We are going on a literal construction.
So, my lord, what I was saying, my lord, apparently these were the purpose, my lord, the beneficial purpose, your lordships. Now, my lord, I'll come back to my lord partnership farm, my lord. Now, partnership farm, if you walk into, my lord, the Act, Income Tax Act, you'll have the same meaning as defined in the Partnership Act. No, what is the meaning, my lord?
A compendious
Name. Or collective name.
Association.
Yes, collective name, nothing else. They are categorically, my lord, these authorities I have relied before the income tax, and I have, my lord, compilation also, my lord, starting from 55.
No, your compilation we look at only to the extent you refer to them.
Lordship.
You throw papers at us, we are not bothered about it.
My lord, this has been
Only when you refer to it, we'll look at it.
Lordship. Shall we refer? Where is this? This one? No, Dulichan. Dulichan. Paragraph.
There is also a principle, Mr. Sen, that
Lordship.
when a specialized body like a tribunal, just like in Mother Superior's case, last paragraph says that there is another principle, unrelated principle, and Justice Nariman refers to that, that when it's a local law and the High Court interprets the local law in a particular manner, then a lot of respect has to be given to that. It's a very old principle. In fact, prior to the recent rubbish that has come out over the last 15-20 years, very few local laws would be interpreted by the Supreme Court contrary to how the High Court interpreted it. Because the principle followed was that the High Court knows the local situation, the backdrop in which the law was made, the mischief that it was sought to arrest, or the benefit that it sought to confer. It's only in very recent times that High Court interpretation of local law has been, but Justice Nariman has, bucked the trend, so to say. And similarly, there's another principle. For instance, the Company Law Board, which deals with all company matters, comes up with a particular interpretation on the basis of its experience and its specialization in that field. It commands a lot of respect, unless it is found to be absolutely arbitrary and absolutely contrary to settled judicial principles. And if it is a possible view, then that regards respect. Similarly, if it's the cess tax that it's a specialized body dealing with in a particular field, similar will apply to an income tax tribunal, because it deals with a particular set of matters as to taxation. And if a possible view has been taken by that, then that commands some respect. Of course, we'll have to go into, because it is conscious that Mahari has been delivered by our jurisdictional High Court. It is conscious of that. But it distinguishes Mahari on the Dilip Chandra principle. And the Dilip Chandra principle works despite Mother Superior in this case.
My humble submission, my lord, so for tribunal declaring the law, my lord, and those who were the High Court as par incuriam, that perhaps is not appropriate.
For whereas?
It has been declared as par incuriam by the tribunal. The tribunal should not have.
That is because of the sycophancy that is prevalent in this country. a single judge of the High Court has authority to refer to a constitution bench and say it's per incurium, if he can show it's per incurium. But it's the sycophants in our system which prevents that and which is an impediment to the development of law. The tribunal has cited the Supreme Court to say that this was not taken into account by the High Court.
Lordship.
The tribunal has not called it per incurium. It should have. The tribunal has just said that this is contrary.
Per incurium. Tribunal has
You
said
show us.
Yes.
You show us which are the judgments that you want to rely on.
Okay. See the per incurium. This is what? My lord, Duli Chand, Lakshmi Narayan, that is my lord, 1956, your lordships.
Is it part of any?
They have referred to in the tribunal has
Yes,
referred to.
have you included it in
Yes.
any compilation?
Yes.
Which one?
My lord, page.
Paper book relevant extract of laws and citation.
Page.
Okay. You're asking page number.
It's number 9 in your compilation.
Yes, my lord. 2833. 28 to 33.
Yes,
Paragraph 11.
56 SCR. So we'll refer to that.
My lord, I'm relying in paragraph.
Just
11.
a second, just a second.
Lordship. ट्राइब्यूनल में डिक्लेयर इन पर
We already read it.
पार्टी को कहाँ पे लिखा है पार्टी
64.
Yes, sir.
Yes, my lord. So, my lord, what 11, paragraph 11, the relevant part. What, my lord, has been said, my lord, in these judgments, that partnerships,
Paragraph 11.
para 11, my lord, if I read.
Partnership is a body of individual.
This is a body of India. I'm just reading it, my lord.
11, 12, 13, and 14. Para 11 to 14.
There is no difference in the general project. How does this help you?
My lord, what I want to convey, your lordships, this is only nothing, my lord, but a compendium of name. So far farm is concerned, your lordships, the income of the farm is the income of the, my lord, individual only. It's nothing, my lord, only two person coming together. Otherwise, there is no legal status has been attributed. That's what I am trying to, my lord, place here before your lordships. So that's
This
what
is confined only to partnership.
a partnership, your lordship.
Only to partnership.
Lordship.
And is what would be a partnership.
Lordship.
And they can be registered, they can be unregistered.
Lordship.
And therefore, this is only giving freedom to unregistered associations of persons forming a common venture.
Lordship.
So this has nothing to do with,
When a partnership is
yes,
the compendious name of partners income of partnership is joint income of two tribal persons.
Yes, my lord, that's because here also, my lord, is a partnership from both the tribals, my lord, belong to husband and
Understood.
wife. So it's their
Understood.
income, my lord.
Understood.
Partner's income means my
Husband, wife, father, son, brother, brother, very close relationship,
We see
but that does not take it out. Is that entity, is that person? Here what we are using is the word person over here,
No, sure.
you say has a wider meaning.
No, sure.
According to you, a person includes anyone who is capable of being sued or who can sue, or a body of persons or an association or the like.
No, sure.
We take it very liberally, provided it is not repugnant to the context. The person over here has to conform to first who you have to be a member of a scheduled tribe.
Singular includes plural.
How are you an association a member of a scheduled tribe? An association is not a member of any scheduled tribe. Over there, the member of a scheduled tribe has to be an individual. So therefore, you're enlarging the scope of person to more than one individual is repugnant to the context of the provision. And even your section 231, section 2 begins with unless the context otherwise requires.
No, sure.
So it's repugnant to the context.
May I submit?
Do you want to submit? My lord, my learned friend. With lordship's permission, my lord, certain procedure.
But that's the end of your submission. You cannot take over anymore. We don't run a relay race over here.
No.
Either you yield to him, after that you sit.
Yes.
You don't stand.
No. So, my lord, what we are, my lord, I am trying to point out, your lordships, it starts with, my lord, person. Again, I am saying, my lord, the opening paragraph starts with person. Then whenever, my lord, it has been confined to, my lord, individual income, my lord, has been categorically said so. Now, in 1026, a member of the scheduled tribe, your lordships, has been mentioned. Now, my humble submission, your lordships, that would include
We follow
also
that. We follow that.
Partnership.
If there's
Partnership
anything else that you can demonstrate, we follow that. But our answer to that, it is repugnant to the context.
Section 50.
Section 1.
Singular includes plural.
No, my lord, that general clauses act we have referred to, your lordships. The general clauses, my lord,
Again, general clause also has that caveat. Unless
Should
the
not be
context
repugnant.
otherwise requires,
Not sure.
unless it is repugnant to the context. That caveat is there in the General Clauses Act. It's not absolute.
In section 54 of the income tax, there is a provision that income is investment in a residential house. So a residential house has been taken as number of units of residential house by the Karnataka High Court, and thereafter legislative has Section 54, Income Tax Act.
If you want to go and come back, we have no problem because this is a matter of
yeah, I understand. It will have
importance.
far-
That's why we asked you
otherwise-
twice.
No,
We asked you twice because you know what.
consequences.
Because we've given you
Lordship has
an indication.
Yes.
We don't have a closed mind.
no.
We've given you an indication what it should be. You can persuade us to hold otherwise. Otherwise, we would not be holding a hearing.
Lordship. So
If we are giving you a chance to persuade us to hold otherwise,
The subject-
and we'd be very happy to hold otherwise.
Exactly, even like because the lordship subject to your lordship convenience, subject to convenience of my learned friend, your lordship matter, my lord, again come up next week. In the meantime, we'll just
After 15 days.
these I understand, my lord. Otherwise, these will have a and lordship will see that Mahadi and Sons. So far, I understand your lordship. Shillong is a small place. Otherwise, this is not only a judgment in ream, but judgment in person also, your lordship. They are, I think, still the beneficiary of that judgment. So anyway, my lord, I'll come back after a week, your lordships.
After 2 weeks.
After 2 weeks. Huh?
After fortnight. Next week I will not be here.
After 2 weeks, my lord.
I'm still going to be there
Lordship.
after 2 weeks. Please realize that.
Yes.
Yes.
No, we'll come back. We'll do it.
After hearing is commenced and substantial submission is made on behalf of the petitioner,
Appellant.
on behalf of the appellant, comma,
No, this will not. What to give?
some time is sought, full stop, paragraph, as requested, comma, let the matter appear a fortnight hence. Please don't think we have a closed mind.
No, my lord.
That's why we read all through
I am grateful to your lordship.
that, because please remember, there's a fundamental principle, and that I repeat in all my judgments. Whenever you're citing precedents, a precedent is a precedent for and an authority for what it actually decides, and not what it is deemed to have decided. You'll find this in Lord Linde's speech in Queen and Leatham, that it is what it actually decides. Just like Justice Nariman said that in Dilip Chandra this passed sub silentio, what you are suggesting has passed sub silentio in Justice Nariman's judgment. Because he dealt only with the purpose of the legislation, not the identity of the beneficiary. We are not on the purpose of the legislation. That purpose we are not questioning. We are on the identity of the beneficiary.
I got it, man. I'll try my lords.
Lordship, my presence may be recorded. My presence may be recorded. Lordship.
Yes, of course it will be recorded.
No, much obliged.
You have such a prominent presence in court.
Item number 5.
1 to 4 are similar, Lordship. 1, 2, 3, 4.
Yes, 1, 2, 3, 4 are all together.
Okay.
Yes, item number 5.
May it please, Your Worship.
Yes.
In this matter, my lord, there are two appeals, my lord. In one appeal, I am the respondent. In one appeal, I am the appellant, my lord. It's a cross appeal. But we have circulated a letter to the government on 20th of April. In response, in fact, my lord, 10th of April, the time was granted, my lord, but it took some time.
You see, sir, we are not, completely immune to what is happening.
Please, my lord.
We also read newspapers, we also read news, and our only thing is that don't make such a demand that the government cannot accede to.
Absolutely, my lord.
Actually, you will try and improve your position, but that does not mean that you take advantage of a situation to get, when you had a piece of land, now you want your piece of land with a building constructed on it.
Right.
Try and keep your level of demand to what is reasonable.
To apprise your kind honor, your lordships.
So we don't want to go into that.
Please, my lord. Please.
So that we don't want to be prejudiced by your negotiations or your, the posturing that both sides are doing
Kindly.
for a legal solution. But if both of you can agree to a settlement, that's the best. But if you cannot agree, this cannot go on indefinitely.
What
It
I
has
have,
to come to an end.
with a kind permission, may I submit? I will have to intervene. In fact, we were not taking part. In fact, appellant and respondent directly, they personally were talking. After the blueprint was provided to the councils, my lord, even Mr. Amit, my learned colleague, will be agreeing to this. The blueprint was provided. After that, immediately there was certain things between parties that no, this is not viable, that is not viable. But there are certain things, if those are being carried, I think the solution is possible, my lord. So we request, a month's time. In this month, what we will do, my lord, there are only 2-3 things like playground. If in this particular area a small playground is prepared, or there are certain 2-3 things, nothing much.
Very good. What we understand from you is that there are various issues.
Yes, my lord.
If there are 10 issues, maybe you've agreed on 5.
Correct, my lord.
And on the other 5 issues, there is no agreement.
Please, my lord.
Now you have to say that if any of those 5 issues is a deal breaker, if it is a deal breaker, it is a deal breaker.
Absolutely. then it
then
goes.
you have to walk out. But if there can be a bit of give and take and adjust in those areas,
Right, my lord.
do that. First, get rid of the issues. Those where you are in agreement, get rid of that. And then identify the 2 or 3 which, you'll ask them to give a bit, they'll ask you to give a bit. It always happens in negotiations.
Yes, my lord.
It cannot be one-sided.
So in both the things, in fact, my lord, it appears that government says, no, we don't agree to this, follow this. And the appellant is saying, no, my lord, we don't follow that. We want amount and a land and this, that. So both are wrong in that aspect. But the blueprint which is provided by the government, my lord, that carries certain things which we can counsel to the appellant.
But you're appealing for the committee.
Committee, my lord. So we'll counsel the committee once again. We'll counsel the committee with the blueprint.
Why don't you involve a trade mediator?
That also we can do, my lord. That
You could involve a trade mediator.
Yes,
Who could kind of, because they're two opposing parties.
right, my lord.
A trade mediator will be able to tell you that, look, you're probably too adamant on this, you're probably too demanding of this.
Right, my lord.
Involve a trade mediator. We have trade mediators here.
We can,
Milord,
we can resort to that also.
we welcome.
The only point
We
would be,
welcome
Lord,
the-
in fact, there are certain things in open forum that can't be said, Lord, because
Absolutely, that's what mediation is.
the
You can say over there,
Yes,
you
yes.
can't bring into court.
right. There are communities, in fact. Now the communities, when these are involved, Lord, then in open forum we can't say like the person who is the mediator of this, that. That is the point, Lord. Otherwise, I think Your Lordship will appreciate.
Yeah, we agree.
this stand, I think.
We agree for common mediator, my lord. Any mediator, lordship deems appropriate. Your
The
lordship,
two of you,
we agree.
the two of you sit down and choose a common mediator.
Your lordship, we agree because
No,
we
not your clients.
Yes, my lord.
I mean the two of you.
Yes, my lord. We need good trained mediator. Any suggestion is from this court is welcome.
Get a trade mediator from elsewhere if you don't have confidence in anyone over here.
Yes, lord. Because
May I
what
suggest
my point is,
another way, my Lord? Mr. Amit is in Delhi. I am also in Delhi, my Lord. The DSGMC, my Lord, Delhi Sikh Gurdwara Managing Committee, who is actually taking care of this Gurdwara committee here, Lord, they are also in Delhi. So we can involve some senior advocate from Delhi, maybe the person of Mr. Amit, and we both can talk about this. And I think, Lord, we can work out.
That is something that the client. We have trained mediators over
Here
here.
also we have
a mediation committee also.
Yes, ma'am.
We have trained mediators. We have trainers of trainers. So I think this is a local issue. Don't take it to Delhi. Don't take it to Delhi. If necessary, both of you come down.
Please, ma'am. Please.
The weather is much better here than in Delhi.
Absolutely, ma'am.
It's cleaner, it's fresher, it's happier. At the request of the parties, let the matter stand over for 6 weeks.
So kind, so obliged, ma'am.
obliged.
We are not saying anything so that
We'll definitely.
our comments don't disturb the process.
Absolutely. So kind, so obliged, Lord. So deeply obliged.
Obliged,
So definitely
obliged.
we'll speak, Lord.
Obliged.
And we'll expedite this, Lord. We'll try, we'll expedite
Please do.
this.
This is hanging for a long time.
Kindly, Lord. So
Yes.
Obliged.